What is a baby's life worth? What is a life worth with now all of these complications that somebody's going to have to live with for the rest of their life if they survive? Their hand in this, it smells a lot like Johnson & Johnson playbook. And I think that this will be a longer tort than people assumed that Depo-Provera was going to be, but that's just my opinion.
If your kids are like hooked on social media or video games, you're right. They are hooked, and it's intentional. Yeah. The algorithm is designed to addict, kids and us to keep playing and playing and playing and playing and playing.
Order in the court.
All right, folks, it's time for our favorite podcast, Cut to the Chase. I know a lot of you out there are like, wow, I really could use an update on a lot of these mass tort cases. Maybe you're a client in one of these cases. Maybe you're an attorney that's handling, you don't even really know what's going on as well. So I figured I would bring Amy Barrie on, who's a specialist in this industry. Amy, explain what you do, and then we'll cut to the chase and get into a bunch of these mass tort cases.
Sure. So I've been with Broughton Partners for 7 years, and Broughton Partners really specializes in consulting and advising law firms on how to build and diversify their practice within the mass tort space. So a ton of what I do for my clients is bring them up to speed on what's happening in various litigations, kind of the ear to the ground information. And we work with the top litigating firms in the country, like Whites and Luxembourg, Arnold and Atkins, Simmons Hanley Conroy, just to name a few. There's a few more. And we refer a ton of the cases that we sign up into those law firms' docket. So it's a great opportunity for personal injury firms or firms that are looking to dip their toe into mass torts, but don't want to make any mistakes, to strategically get involved and for us to do the heavy lifting and for those firms to do the heavy lifting as well. So.
All right, outstanding. So let's go on to the first one that's actually been in the news recently. J&J with their talcum powder, baby powder, was causing ovarian cancer, mesothelioma. The case has been going on for over a decade, 30,000 people and ladies involved in these cases. A lot of them were dying during these cases. J&J is trying to file for bankruptcy on this. How is J&J, a Fortune 500, filing for bankruptcy to Texas two-step? It's too tough to get into the weeds on all this, but there's an update. So Amy,
yeah. So Red River is the subsidiary company of Johnson & Johnson, and they are basically housing all of the Johnson & Johnson baby powder sales within that company. And it's a really strategic way for big pharma companies to remove liability from themselves. And so this is exactly the play that Johnson & Johnson is doing. And that bankruptcy trial is currently underway. This is the most significant mass tort trial of the year, taking place in Texas, testing Johnson & Johnson's latest attempt to offload those talc liabilities. So this trial will determine whether Johnson & Johnson use of the controversial Texas two-step bankruptcy maneuver holds up in court. So, a ruling here could set a precedence for future corporate liability spinoffs. We're all kind of sitting on the edge of our seat, seeing how this one shakes out.
Now, some of you might have heard, wow, I think I heard this J&J Texas two-step on a couple of your earlier episodes, Greg. What's going on? So this is actually the third time that they're in a different state with a different subsidiary, but the same arguments about whether the filing for bankruptcy is in good faith or not. So I don't see this story ending anytime soon, where whichever way the judge rules, I'm sure is going to get appealed. And
yeah,
we're offering $10 billion. So
yeah, it's just a sad story all in all, especially for the claimants. Like, you have these women that are fighting their lives for, with ovarian cancer. And, if any of you personally have been through cancer or have had a family member walk through it, like, that's just stressful enough. So we really hope that justice prevails for these people, but, we'll see.
Well, they have offered some money, $10 billion. I know there's a lot of the mass tort attorneys that are kind of, running the show that think that that's way too low. So we'll see where that goes. All right, next one. The new shiny toy is the Depo-Provera. another
Birth control
birth
product. I
control.
would
Sorry.
say pregnancy maybe under the same umbrella, but it would depend on whose opinion that is. Yeah, so Depo-Provera, we've talked about this on your podcast before, and the really interesting thing about this litigation is when it first came out, everybody was so excited about it. Like, we really needed something new in the mass tort space, and we really thought that this was it. We thought, and a lot of people assumed, there was no preemption issues on this case. There was no preemption issues on this case. You had one signature injury, you had off the chart causation. When we were filing for where we wanted this MDL to be consolidated, which was in California, the defense threw back and was like, hey, just to let you know that we tried to warn Pfizer that this stuff caused meningioma, and they denied the label change. So if this was true, this whole thing would be preempted. So what we did as best practices is, for the campaigns and the law firms that were getting involved in this, we actually went to them and we stopped all of our marketing for this, because we just wanted to take a pause and breathe for a second and map out, all right, if X happens, what is the strategy there? If Y happens, what is the strategy there? If it gets, approved in this MDL, how are we going to shift? And it didn't end up in New York, and it didn't end up in California. It ended up in the Northern District of Florida under Judge Casey Rogers, which, she's been in the mass tort industry before. She's the reason why 3M settled so quickly. Well, if COVID wasn't there, 3M would have settled much quicker. And so we're excited about Judge Casey Rogers being in this. We still have really strong epidemiology linking Depo-Provera to cerebral meningiomas. We're still optimistic, but with this kind of card Pfizer laid on the table, it just really goes to show their hand in this. It smells a lot like Johnson & Johnson playbook. And I think that this will be a longer tort than people assumed that Depo-Provera was going to be, but that's just my opinion. Some people are saying bellwethers in 2027. I've been in this industry long enough to not assume the future, because I don't have a crystal ball and anything can happen in the world of mass torts. But this might be a 3-year, this might be a 5-year, this might be a 7-year. So we will just wait and see. So
Okay, so Judge Rogers now has the case. She had the 3M litigation. She tried like 19 cases in a very short period of time, short in the world of litigation. So everybody's sort of excited that she's running the show here. I guess when I say everybody, a lot of people. So, I read through your Mass Tort Digest, which kind of went over a lot of these issues. And I think you were projecting like 15 to 18,000 potential people with this meningioma brain tumor from
yeah,
Depo-Provera.
our TAM analysis kind of shows around, that mark. Some people think a lot more, but that's just based off of our calculations within the age group and how many diagnoses of meningioma there are. Cerebral meningioma, the amount of women that take Depo-Provera. And then also too, what we're doing to be even more conservative in our vetting analysis is we are not signing up 7 states, given their laws on design defect and the discovery rules on them. So that's taking about 50% of the market that we were signing up previously out of the gate right there. So we are focused on Pfizer's failure to warn on this case. So I think that's the approach that leadership, when it's formed, is going to kind of steer forward on this.
So the design defect is that there was an alternate design that had less problems than the Depo-Provera. Did I get that right?
I believe so, but I'm not going to take a hard opinion on that because I'm just not sure. I'm not really into the science weeds as of right now on that. I just know that we want to take a very conservative approach onto what we're signing up, given different state laws on design defect and failure to warn and their discovery rules.
All right, now let's move on to Roundup. A lot of people have heard about Roundup. It's, still on the shelves. You can still get Roundup. Some countries ban it. There've been a lot of trials. There are a lot of settlements, but there's still a lot of cases out there. What's the latest on that, on Roundup?
I mean, yeah, there was not some really good news on Roundup in Missouri earlier this week. So the House approved a bill aimed to protecting Bayer from pesticide lawsuits. And so what this bill mainly streamlines pesticide registration in Missouri and clarifies that the EPA approved cancer warnings are sufficient for state requirements, potentially preventing the need for additional state-specific cancer warning labels. So, this is greatly going to affect the cases that are in Missouri, not other states. It would not impact federal litigation or cases in other states, like I said, but for existing cases, it may not directly affect already filed cases due to legal principles about reactive application, but it could influence settlement discussions of pending cases, or it might affect appeals of existing verdicts. For Bayer and Monsanto, what this does is it really provides stronger regulatory compliance defense for them. It aligns state requirements with federal standards, and it could reduce future liability exposure in Missouri. I think that this bill appears to be part of a broader trend of states attempting to address the conflict between EPA's position on glyphosate and the numerous jury verdicts finding Roundup caused cancer. This would only affect Missouri cases and would not impact federal litigations or cases in other states. It's going to be crucial if you are involved in Roundup right now that your cases are with a firm that has really strategic state court strategies. I won't name the firms that we're currently working with, but those firms definitely have a really strong hold on their position and kind of what the future looks like for those inventories. But I would be concerned if I were kind of a smaller firm trying to handle some Roundup cases myself.
Gotcha. All right. So the last thing on Roundup, speaking of Missouri, is apparently the Missouri Appellate Court just upheld a $1.25 million verdict against Monsanto. So even though there's this bill floating around that could affect Missouri, Missouri's Appellate Court signed off on a verdict.
Yeah, I mean, it's comical because that verdict was upheld by the Supreme Court, stating federal law had no effect on state law. So it just kind of stinks like a big political payoff to me.
Yep. All right. Well, that's the way of the world. All right. Number 4, NEC infant formula.
Yeah, this one is one to watch for 2025, and we're very excited about this litigation. We're talking about babies at the end of the day. On February 11th, defendants in the MDL moved for summary judgment. So basically arguing that plaintiffs lacked expert testimony to prove that cow's milk-based formula cases causing NEC in infants. But what they were seeking to do is exclude the plaintiff's expert. His name is Dr. Logan Spector. And there was another doctor, Dr. Jennifer Sucre. I think that's how you pronounce her last name. I'm just going to blame it because I'm Canadian and I can't pronounce anything. But under Rule 702, which, if successful, it would leave plaintiffs without essential causation for evidence. But we are confident that that is unlikely going to happen. The defendants are up 2-1. Our trial partners that we're working with, Stranz, Jennings, Garving, they have a really good history in the courtroom with these defendants. They've won all of their trials that they've been under against these defendants, and so they're excited for their next one.
So there have been 3 trials last year, and 2 of them went for the plaintiff and 1 went for the defendant, or the other way?
Correct. Yeah.
Yeah. And so one of the verdicts was like a $500 million verdict. So it's big numbers here, but you're talking about babies and this is
You're
really,
talking about lifelong care, right?
yeah.
And also, like, when you ask when you ask yourself, like, what is a life worth? What is a baby's life worth? What is a life worth with now all of these complications that somebody's going to have to live with for the rest of their life if they survive? Or what is a life worth that has been lost at so young, right?
Okay, so yeah, I mean, money really can only do so much, but it's the best compensation that's out there. So, all right, let's move on to paraquat. Paraquat is sort of like the Roundup, but it's not the same as Roundup. So tell me about paraquat.
Yeah, so when you're comparing paraquat to Roundup, paraquat is a much heavier chemical. So when it's sprayed, it goes directly down. That's why it was really difficult to prove up the drift cases, right? And so in Roundup, I believe because the chemical is lighter as well, when you spray it, it's easier to ingest. But on paraquat, there is also an MDL play and a state court play on this. As I develop my career in mass torts, we're finding that state court plays are really strategic for plaintiffs. And so I think we're going to start seeing a lot more of these state court plays in these various litigations, like we're seeing in paraquat and various others. It's under Judge Rosengel. Am I pronouncing that name right?
Rosenstengel.
Rosenstengel, thanks. So there are 6 cases for full case specific discovery that's working up right now. The trials have been pushed to June in 2025 for the state court play in Philadelphia. And then the MDL bellwethers will start, they're set for trial on October 15th. And so we're just waiting for the summary judgment, and Daubert motions are due in August. So we'll be hearing a lot more updates on, how things progress on paraquat within the next few months.
One of the bigger mass torts that came out last couple of years is the hair relaxer. And so that's moving along also. What do we got going on there?
Yeah, so bellwether sections are underway. Each side will select 20 cases by May 9th, totaling 40 cases. So there's individual case workup that will continue into February of next year, followed by expert workup. The selection process is really going to indicate which cancers both sides believe are strongest. So I'm excited to see kind of what that looks like with
Bellwether's mediation coming up or selecting a mediator. I guess that's also on the table.
Yeah, that's on the table. So, I think we'll start seeing a lot more in next month. So March 20th is when they'll be selecting a mediator. So we'll see. We'll see on that one. I know the science on that has been a little bit hard to navigate, but I believe in the plaintiffs, and I believe in the plaintiff steering committee that's selected on this, that they'll do a really great job for these people.
Nice. All right. So one of the mass torts that it doesn't really make a lot of headline news is the bear hugger. So this is the device that they give patients in operating rooms to keep them warm after the operation. What's going on with that? I mean I thought that case was thrown out like 3 years ago, but I guess it returned somehow.
I mean, yeah, I guess that there's some movement on that. We didn't get involved in Bear Hugger as a company. We just kind of stayed on the sidelines with that. So I'm not as well versed in it as, some other people might be but from what I understand, there was a big win for the plaintiffs in a bellwether case. And so with victory in the summary judgment and the Daubert rulings, obviously it just strengthens this litigation. And I thought that this was thrown out as well. So I was quite surprised to see that. But, the outcome of this bellwether case, it could really shake up what we see in Bear Hugger moving forward. So that's kind of all that I can say on it. But I was kind of just as surprised as you were.
All right, so let's move on to the social media addiction with the Section 230, kids getting addicted intentionally to social media. And we got video game addiction, but let's talk about the social media addiction case.
Sure. To be honest with you, I'm much more excited about these video game addiction cases than I am the social media addiction cases. But I think we'll start seeing a lot more buzz on video game addiction within the next few months. The social media addiction, they are kind of in the trenches right now when it comes to battling it out. And so there was really some positive early rulings found that in Section 230, it does not provide blanket immunity to the social media companies. So like Meta, the MDL is in California under Judge Cool, and he denied the defendant's motion to dismiss, allowing cases to proceed. So we're excited with how that one is trending. And so a bellwether trial is expected in late 2025. I don't have a specific date for that. It might be delayed into 2026, but the defendants are expected to obviously challenge rulings aggressively. Like, these guys have a ton of money in their back pocket. They can afford to fight in this. But on Valentine's Day, just what was that, last week? The MDL judge signaled that she will likely deny Google and Snap's interlocutory appeal requests, so calling them impractical. So she also dismissed Google's Section 230 argument. She noted a similar Meta appeal is already before the Ninth Circuit. So, frustrated with insurers pushing for an early coverage dispute, she called their motion unprofessional. So no rulings were issued, but her stance was very, very clear on this. So when you are talking about these big companies with massive pockets creating algorithms to addict people and addict kids, I just think that there's kind of no shenanigans that goes on with pursuing that. As you can imagine, the criteria to screen one of these claimants is very tricky to be conservative in it, but I think we have a very tight-knit criteria on what we're targeting, and our counsel that we're working with is very pleased with the cases and claimants that we're able to deliver over to them.
All right, so let's do a quick video game. It's the same thing. Folks, if your kids are like hooked on social media or video games, you're right. They are hooked, and it's intentional. The algorithm is designed to addict, kids and us to keep playing and playing and playing and playing and playing. So what's that? Video games that's like the new kid on the block. Do you have any updates on that, or is that just like completely new ball game?
So yes, what I can tell you, because I do have to wrap things up here with you, but they are currently in, just really quick run through of the litigation, is basically they're treating this case as a TBI because the way that kids' brains are forming while they're playing these games, it damages their brain development. It's causing behavioral issues and rage and all of these just incredibly wild things. And you can probably see it in your kids that are hooked on these things. The only thing that I can say right now about it is you'll be hearing a lot more about it within the next couple of weeks. I'm not sure if I have the liberty to kind of share the information that's going on right now, but you will be hearing some things soon. So with that being said, Greg, thank you so much for having me back on your podcast.
Okay.
I always appreciate it.
I appreciate you coming on, Amy Barrie.
I just work at Broughton Partners. Feel free to check us out, look us up. Feel free to reach out to me as well if you have any questions and kind of wanted to have a more in-depth conversation. Greg can put my contact info at the end of this.
I will. So any further questions, talk to Amy. She'll update you. Amy, thank you for coming along. And that'll do it for this episode of Cut to the Chase. Comment below if you got questions. Let me know what they are, all right?
Thanks, Greg. Bye.
That's all for this episode of Cut to the Chase. But before you go, will you open up your podcast app and give us a 5-star review? You can also leave a comment about what you liked most or other topics you'd like us to cover. And please be sure to subscribe so you don't miss any upcoming shows. Thanks, everybody. Be safe out there.